The Third Amendment to the Constitution states, "No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." Unlike other amendments in the Bill of Rights, this amendment has not actually been the basis for much litigation, nor has it been the subject of much public debate. In fact, the Supreme Court has never made a decision based on this amendment. But there is a reason the founders felt this amendment was important enough to include in the Bill of Rights. Throughout history, since ancient times, conquering empires have quartered soldiers. For example, the Roman army often practiced this as a way to provide free housing for soldiers, but perhaps more importantly, it was a way to control the residents of a region by having an army stationed in the very homes of the residents of an occupied region. This is essentially what happened in the lead-up to the American War for Independence. The English had created a law back in the 1600s that restricted the quartering of troops in homes, which had happened quite frequently during the English Civil Wars. But this law did not extend to the English colonies until the first Quartering Act of 1765. But this law did not extend to the colonies, and there were exceptions. Most importantly, the colonists still had to pay the cost for housing troops. The Second Quartering Act was then passed by the British Parliament in 1774. It extended the types of buildings that could be used for housing troops, though contrary to popular belief, private homes that were occupied were still legally off limits. As the Constitution was being created, many were concerned about the power of the newly forming federal government. Since the Constitution granted the federal government the power to maintain a standing army, some states were concerned that this standing army might be ordered to take up residence in certain states and therefore be used in much the way the ancient Romans had used it as a tool of oppression and control. Thus, the Third Amendment was added to the Constitution. Although the Supreme Court has not dealt with the Third Amendment, the lower courts have on a few occasions. The most notable case is that of Ingram v. Carey. In the late 1970s, a large number of New York State correctional officers went on strike, and the National Guard had to be called in to keep the prisons running. These National Guard troops were then stationed in the prison's on-site housing, and the prison guards who had lived there were then evicted. One of them sued. This case established three precedents. The National Guard are included in the term soldiers. The Third Amendment also applies to the actions of states and state militias, not just the federal government. And the term owner in the Third Amendment does include tenants who are renting. Although there has not been extensive litigation based on the Third Amendment, this amendment is still important. It's an important part of the constitutional principle known as the right to privacy, and like the Fourth Amendment, represents the general idea that people are protected in their homes from government intrusion.